Supreme Court's July 11, 2024 judgment includes far-reaching decisions that will significantly alter local government administration in the country. The Supreme Court has affirmed the financial autonomy of Nigeria's 774 local governments. In a unanimous judgment of its 7-member panel on July 11, the Supreme Court unanimously upheld the suit brought by the federal government to strengthen the independence of local governments in the country. A member of the panel, Justice Emmanuel Agim, who delivered the court's lead judgment, held that the local governments across the country should, from July 11, receive their allocations directly from the Accountant General of the Federation. He ruled that it is illegal and unconstitutional for governors to receive and withhold funds allocated to local government areas in their states. He ordered immediate enforcement and compliance with the orders of the court by the state governments and successive governments henceforth. Today, we'll be discussing an important part of this judgment, and that is the local government tenure elongation by the Supreme Court. The judgment partly reads, under Section 135, subsection 3 of the Constitution, the tenure of 4 years for the President, provided for by Section 135, subsection 2 thereof, shall be extended for periods not exceeding a period of 6 months at any time by a resolution of the National Assembly if it is not practicable to hold elections. By the same token, by a law of a state house of assembly, the tenure of local government councils can be legally extended for any reason such as insecurity or war if it becomes impracticable or impossible for elections into the local government councils to be conducted. The mandate given to an elected local government council is the mandate of the electorate of that local government area, and if the tenure is extended, it is the people's mandate that is extended. If the tenure of a local government council is truncated, as it is the norm now, it is an illegal termination of the electorate's mandate, and it is not to be encouraged, but roundly condemned. Also joining me on Open Conversation this morning is Associate Professor Emmanuel Warner. Associate Professor Emmanuel is an Associate Professor, Department of Political Science, University of Port Harcourt. Good morning and welcome to Open Conversation.
Thank you. Good morning.
Yes. Now, following the story, what is your reaction on the Supreme Court upholding local government tenure elongation?
Well, I think that's in tandem with the tenets of federalism. Nigeria is a federation, and is practicing a federal system of government. We are aware of the fact that federalism is like a spectrum, and at a point in that spectrum, the Nigerian society, Nigerian government has decided that a third tier of government should be part of that federal arrangement. The essence is to ensure that there is decentralization, which of course will enhance development in the rural areas. I mean, bring government closer to the people. And by that token, there is a constitutional arrangement that reflects that. But given the 1976 local government reforms, that tier of government became constitutionally recognized as the third tier of government. And given the provisions in the federal system of government, the tiers of government are expected to be autonomous, given the devolution of functions and powers, to the different tiers of government. And so what that means, therefore, is constitutionally speaking, and by the arrangement of Nigerians and those who drafted that constitution, it means that local government, by virtue of constitutional provision, which we respect as the ground norm of our society, is expected to enjoy that autonomy, fiscally and otherwise. And so what that means, therefore, is that the judgment of the Supreme Court is an affirmation, a confirmation of that constitutional provision. And that is why it's important for us to understand the fact that in a democratic system of government where, it is expected that the theory of separation of power should be upheld in terms of actually dividing the functions of the society, governmental activities into the different organs of government, to the extent that each organ of government is expected to, perform specific functions. And given that, by extension, you have, checks and balances. What that means that, in spite of the fact that, or despite the fact that you have separated organs of government, there should also be checks and balances. The essence is to, avoid arbitrary rule and ensure that, the government of the day is a constitutional government rather than that of the whims and caprices of leaders of the society. So I think it's important for us to begin to look at, that judgment and see how it relates vis-a-vis what I call very, very internecine disrespect and disregard of the constitution of this country. Like my colleague just pointed out, if we are thrown into the Hobbesian state of nature, where we don't even look at the constitution, the laws, because human beings, naturally speaking, we have these, sometimes I used to tell my students, I used to give them this conundrum. Is it true that a normal human being is also a mad person? And we have argued and seem to have come to the conclusion that yes, because if you don't have laws, there is the tendency that human beings will begin to exhibit those animalistic tendencies, which Thomas Hobbes taught in the state of nature, where life will be short, solitary, nasty, short and brutish. And nobody will like that kind of society, So it's important for us to begin to respect and, obey the laws of the land. Because what we are seeing currently in Nigeria is the fact that, particularly with regards to local government autonomy, is the fact that, state government, given the nature of politics in Nigeria, have actually, violated this very important aspect of the Constitution, where, local government caretaker committees are appointed without recourse to the provisions of the Constitution. I listened to some people here in Rivers State, even including the governor, when he alluded to the fact that where this is done in other states, is our own state different? And again, to the fact that where the past government of Nyesom Wike also did it. So, can you justify that because other people have done that? Or will you also say that because somebody killed somebody in Abia State and the person was not arrested, so it is justifiable that you should kill somebody in River State? I don't understand. And it also explains the fact that there is what I call executive rascality in this country, given the fact that, over the years, and it bothers me that the attorneys general of this country over the years did not do what this present attorney general did. You are the law officer of the country, and by virtue of your position and the judicial system that's supposed to serve as watchdog, these things were done without any recourse to the fact that they are breaching or violating the constitution of the country, and thereby setting very, very dangerous precedent, which some people are now beginning to refer to. But be that as it may, we are aware of the fact that constitution is the ground norm of every society, and the essence of having a constitution is to actually regulate the behavior of human beings so that it will be in tandem with a civilized society. Because civilization is a very, very veritable instrument for development. If you don't have civilized citizens, by virtue of the fact that every citizen should be amenable to the provisions of the Constitution, what that means, therefore, is that you are creating room for people to begin to behave anyhow they like, and then apply the Constitution selectively, like the way it is being done now. Selective application of the provisions of the Constitution to suit, parochial and selfish interests. So I think that it is important that at every given point in time, we should be able to actually have a recourse to the provisions of the Constitution. What that also means to me is that I was reading that judgment today, and I felt that. In fact, to me, I was like, these men are very, very thorough in this judgment. Because aside from the fact that they were able to, jettison those preliminary objections in terms of if the Attorney General has a local standing and whether, they are going to transfer, but the registrar did not sign the originating summon. And they were able to also condemn that. But the nitty-gritty of that judgment, which I think is very, very paramount in this issue, is the fact that, look, you have a third tier of government, and that third tier of government, by constitutional provision, is expected to live a life of its own. Maybe the autonomy thing is confusing us. That tier of government is expected to live a life of its own. But it is a very, very condemnable actions of politicians in Nigeria over the years that, they tend to do everything almost outside the provisions of the Constitution. What informs you, what gives you that constitutional, authority to begin to appoint, caretaker committees. And even as it has happened in Rivers State, I want to also make reference to that. It's the fact that, look, given the fact that a Supreme Court, and that's the highest court of the land, has given a judgment, like you just read, with immediate effect. You still have here in Rivers State people who are still parading themselves as caretaker committee chairmen. Sometimes I listen to them in radio, commending them, making decisions, making policies, making this, and we are keeping quiet. What does it show? It shows utter disregard. It shows sheer rascality to the constitution and authority of this country. A Supreme Court. We're not just talking about any other court here. We are talking about the Supreme Court of the land. And some people are still calling themselves caretaker committee chairmen. People are congratulating them with impunity. What are we talking about in this country? Where are we heading for in this country? Because I know that if there is a pronouncement, even at the lower court, if a court makes a pronouncement, a ruling, it stands, except that ruling or pronouncement has been vacated by a higher court, given the hierarchy of courts. By now, we are talking about a Supreme Court. Yet, you still find people, I don't know where they are coming from. I don't know if they don't have any regard. In fact, the last time I listened to...
Are they not empowered by the governor? The governor actually inaugurated them as caretaker committees. So, if the governor had asked them to resign, I am sure they will not be parading themselves. So, is the blame going to these caretaker committees as right now, or to the executive arm of the state?
Well,
who empowers them?
When you talk about executive arm, that executive arm does not exist in a vacuum. It's made up of human beings who are Nigerians. Whether you are the governor or you are the caretaker committee chairman appointed, or you are just ordinary Nigerians, you are subject to the provisions of the Constitution of the land, especially when that has been expressly interpreted by a Supreme Court in this country. So when the court has given that job, it don't need the governor to come and tell you, okay, I've dissolved you. You don't need that formal pronouncement.
They should resign.
They should resign and should stop parading themselves as local government care committee chairman. That's what it means. You don't need the formal declaration by the governor, because the governor is also a citizen for the first instance.
Who funds them?
Well, the issue of funding, and of course from the judgment, they were told that funds meant for local government should not be paid to the state government account henceforth from July, and what that means that if they are expected to function, then maybe they should be looking for alternative personal or charity organization donations for them to perform. Even when they do that, they are not supposed to, officially speaking, begin to use such money, governance for the local government areas. They are not, because the law, the Constitution, by the virtue of the pronouncement and ruling of the Supreme Court, bars them from that. So we see, we live in a society where people, want to live above law, acting out of bias, and then when it is against their wishes and aspirations, they shout. But when other people also, by virtue of their actions or inactions, disregard, constitutional provisions, these other people will also shout. But how can you live in a glass house and begin to throw stones? You are condemning illegality. You are condemning people who don't obey court orders. Yet in your own actions, you are not obeying court orders.
Okay.
So where are we moving from there?
All right.
I think we need to appeal to our conscience and begin to adhere strictly to the provisions of the Constitution of the land.
All right. Emi, what is your take on this issue? And I would love you to also narrow it down to the current reality in Rivers State.
The essence of law in a society, it is not just for the sake of the law, but to define actions that are acceptable and also to state actions that are prohibited. All of these are meant to ensure that there is harmony that can drive development in the state. But when the people decides, to disdainfully disregard that law, they just know that there will be problem. Development will be hindered, peace will be hindered, and what you will be seeing is social vices, because every man will become right in their own eyes, because the law is meant to regulate this. You see, right from the day the 1999 Constitution was adopted on May 5th, 1999, I become operational May 29, 1999 to date. The law has never given room for caretaker practice in the Nigeria state with regard to the third tier of government. When people say our problem is the Constitution, because that has become one of the sophistry that we hear around every time, here and there. Oh, Nigeria Constitution is faulty. Nigeria Constitution is bad. Nigeria Constitution is anti-development. Sometimes I ask them, if a law, for an instance, says AFRI, which is public fighting, is a crime, and some people still go ahead and be engaging in this fighting in public places, is it the law that is the problem, or the implementers and the citizens who have refused to respect the law that is a problem? You see, Section 1 of the 1999 Constitution as amended, subsection 1, state the supremacy of the law over all authorities, individuals, whether you are a federal government, you are a state government or local government, whether you are a politician or not politician, whatever category you find yourself, the law is supreme above you. And subsection 2 of that section 1 then clearly stated that no persons or group of persons shall take over the government of Nigeria except it must be in accordance with the written law. But what do we have in time past? Like Prof actually said, we see people who have abandoned the law, people who decided to jettison the law and become very recalcitrant to the extent that you mentioning the law is like you are attacking their personality, and they will even come after you, to discredit you, insult you. More painfully, you will have some other Nigerians applauding such action and even demonizing you, calling your sorts of names, that you are demarketing their leader. And the same Nigeria will turn around and organize protests when it is not in their favor anymore. The same Nigeria will turn around and begin to vilify, castigate the system. Oh, the Nigeria system is bad. The question is, have you been encouraging the system? What seed are you be sowing into the system? The law clearly says in Section 7 of the 1999 Constitution that what is permitted to run the affairs of the third tier of government, which is the local government, is democratically elected persons. But we have some persons who were elected by the virtues of the same ground norm, who developed and became emperors, at the state level and decided to disdainfully disregard the law that made them governors and decided to appoint or be appointed people to run the affairs of the local government. There was a forum where I asked, you that is supporting that, yes, you did it out of necessity. Oh, you can't leave government in vacuum. Oh, you can't do this as based on the political situation in Rivers State. Therefore, we are appointing caretaker. I said, that is good. You that is appraising this, would you accept a caretaker governor? Should we not say, President Tinubu, please, oh, based on the current political situation in Rivers State, please give us a caretaker governor? Will you accept? He said, why will you say a thing like that? Why will you say, does he have the power to do so? No president have the power. I'm an enemy of state. They started calling me names. I say, yes, if I'm enemy of state, then who are you? Who are you? And this is what we are saying. The apex court in the land have so decided in a judgment that is binding. In fact, when you look at the list of the defendants, Rivers State is listed in number 32. Meaning Rivers State is inclusive. Where the apex court so ruled that anything that has to do with caretaker is illegal. Anything that has to do with ad hoc government at the third tier of the government is illegal. You still have some people parading themselves. You still have a governor voting funds for these people to function in a democratic state. Not just a constitutional democratic state. And the people are celebrating, giving thanksgiving in churches, or going to places and congratulating them even in public spaces without shame. And we still want Nigeria to work. How? I have my interests. I have things that I want to drive in the society. But if I juxtapose them with the laws of the land, I will be so restrained. If I believe that this thing is illegal, I might be punished for it. But you are now saying, no, you should not be restrained. You want to do your own the way you like. What about in the situation today, if the outgone local government chairman decided to say, no, today we have resumed, and goes to the radio station, TV, and be running congratulatory messages, and going to places and be performing some government functions and all that, will this caretaker accept it? They will come and say, no, some people are usurping the powers of government. Whereas some people are actually criminal parading themselves in the name of caretakers. Who then do I blame?
That's the question.
I will blame the institution of the states. When I mean the institution of that, I will blame the police, and I will blame the president of the Federal Republic of Nigeria.
All right.
Why will I do so? You swore to an oath to protect the Constitution of the Federal Republic of Nigeria. The police, you were there existing to enforce the law. Do you know that law becomes very effective if the law is enforced? But it becomes so lenient, you will bet more problem that will overwhelm you even as a police. The president of the Federal Republic of Nigeria and the police ought to be arresting those criminals, those usurping the powers of government, are parading themselves as caretaker, because the law prohibits such action, in fact forbids such action, and call them illegal. So you are meant to enforce this law to ensure that whenever you find them, you arrest them for usurping the power of government. It's a criminal offense. But what do we see? Sometimes we even see the police providing security to illegality. So what is the difference between them and armed robbers who go about robbing people of their belongings? So it is expected that you should provide security to these robbers as well. How do we continue to drive in this trajectory and expect that we have a state where we experience harmony and tranquility? It is impossible. The law has stated. Supreme Court has affirmed it. Supreme Court didn't do anything on that. There was no judicial activism there. What they did was simply to read out what the law says and what is expected. I listened to some of these arguments in the state, in Rivers State, where some people say government cannot be left in vacuum. Because we must have people running the affairs of government. Since local government election wasn't conducted, and I ask, who created the vacuum? Who? Is it the Lord that created the vacuum? Is it the federal government that created the vacuum? Is it the court that created the vacuum? Or the executive government of Rivers State that created the vacuum? So why would the executive government be telling me that there is no vacuum, so we can't leave the third tier of government instead of vacuum? You knew that your tenure expires on the 28th of May, 12 a.m. Your tenure have expired. The president is aware of this, so the president will always encourage the electoral body to conduct election before the expiration of his own tenure and the tenure of the government at the subnational level. You, the governor who is in charge of the state affairs, you knew that the tenure of these people will expire June 17, 2024. But you were elected and inaugurated May 29, 2023, meaning you have 1 year and be living with this information. You refuse to empower the electoral body at the state level to conduct an election that will replace the outgoing chairman. There you now came, oh, you can't allow the vacuum. A vacuum that was created by you, a vacuum that you orchestrated for your own selfish political drive, that you want to impose something illegal structure that you will now call your political structure at the state level, undermining the ground norm that even established you as a governor. And you're not saying, no, there can't be a vacuum. The vacuum is your own fault. It's your own problem. So the Attorney General of the Federation has done his own part. The police ought to go about arresting these people who are parading themselves. If the governor they say, oh, give us some time, you don't have time because you have all the time to encourage and empower the electoral body at the state level, but you refused. So you should be punished for it. You should not have this structure, this illegal structure in place. You must be made to face the music the way it ought to be, following the law of the land. And you that submit yourself to be used to that extent, you need to pay. Because you are now helping to destroy the Nigeria state by disobeying our law.
All right, Amy, I wanted to ask you a question when you were speaking. You made mention of funds being given to the caretaker committee, and you were looking at the direction of the Supreme Court, instructing that allocation should not go to unelected officers or chairmen at the local government level. Now the question would be, in Rivers State, against the Supreme Court judgment, these caretaker committee chairmen are still parading themselves as council bosses, as it were. How are they going to get funded? Because if they cannot receive allocation from the federal government, how do they run their councils? How are they getting funded? Is the governor funding these people from Rivers State's money as against what the Supreme Court has ruled that their funding will come directly from the federal?
You see, what is on the hand does not need mirror to look at it because you already have it in your palm already. Who is funding these illegal people who are usurping the power of government? It's obvious that the governor is funding them.
Isn't that misappropriation of funds, one? And isn't that constitutional infraction by the governor?
Currently, Rivers State, if you talk about constitutional infraction, you will not ask which of them is not actually constitutional infraction. Rivers State is in a state of illegality. Everything has to, if you judge majority of the political situation in the state, and you judge some of the actions taken by government at the state level, you see that there is so much illegality. Everything is shrouded in illegality for one to another, from the other to another. This is what is happening.
All right.
If we continue to do this, I can assure the society that development will be artificial. And once you continue to drive artificial development, the reality will come one day just as we are facing now, where peace will elude us. A situation like Prof actually said, Thomas Hope envisaged this, and he recognized and recommended that people should submit to the rule of law. Because if we don't do this, It therefore means that we have a state of nature. And in the state of nature, nobody respects the rights of the other. Everybody will want to do their own bidding, the way they feel and how they want it. The government might not be safe, because to that extent the government may give order. It will be asked, why are you directing me? What power do you have to direct me? Even when you are not obeying the law.
Okay.
So we must go back to constitutionalism. We must submit to the rule of law. The governor funding illegality is misappropriation and a criminal offense. Because whatever fund that as a state government that you must expend must be budgeted for and approved by the legislative arm of government according to the division of functions as recommended as stipulated by our law. So if you still go ahead and be investing state resources in illegality, some of this is an impeachable offense. That is why when some people say some people should be impeached, they say, what has it done? What has it done? What has it done? And they forgot. If you go to section 188 of the 1998 Constitution as amended, you will see what gross misconduct is. Gross misconduct can be adjudged by the legislature to say, you didn't greet me the good morning well. The manner you say good afternoon, I don't like it. So that amount to gross misconduct. Because now, the law allowed them to so define gross misconduct.
The fact that the governor has refused to obey the Supreme Court judgment and is also funding this council committee, caretaker committee, according to you, is tantamount to gross misconduct and it's an impeachable offense.
Yes.
Right.
The law stipulates what gross misconduct is now, what are impeachable offense. It's there, not me that is actually saying this now. It's what the law says.
Okay.
It's written in our law, and that is the ground law we operate today.
All right.
So it is, in fact, for me, it is abhorring. It's an unfortunate situation to see a man who, by virtue of a law, came to power because there are other more qualified reverse people. There are other more educated reverse people. There are other more politically will reverse people. But by virtue of a constitution, a particular person became privileged and was selected among the millions of other reverse people. And by that, the state resources were entrusted in your custody. You now given issue commands, issue orders, and every other reverse people, including your elders, they are now obeying you as submitting to those things you are bringing up because the law has said you are the governor. Then if you now go about funding what abuses and insult the constitution, the people one day will tell you, Mr. Governor, you can't tell me to do this anymore.
All right. All right. Prof, what is your take? Now, Emmy has spoken about judicial rascality and constitutional infractions by the governor, particularly with respect to flagrant disobedience to the Supreme Court ruling on local government autonomy. What is your take on that?
Well, I think I've said that earlier, but just to maybe reiterate that fact. The Supreme Court is the highest court of the land. And like I said, in a democratic setting, you have theory of separation of power and, of course, checks and balance. So what that means is that judiciary primarily is charged with the responsibility of interpreting the laws of the land, and that interpretation is expected to be upheld and executed by other tiers of government, every personality within the context or purview of Nigerian society. So what that means that it's just a simple affirmation of that constitutional provision. But let me also quickly clear one impression, which of course arises or arose from this illegality in terms of caretaker committee. I listened to some people, maybe because of sheer selfishness or ignorance, I don't know, where they were saying that trying to justify caretaker committee, that it doesn't apply to the caretaker committee, that ruling doesn't apply to caretaker committee chairman in Rivers State. And I began to ask why. When I read that judgment, the judgment relied wholly on the provisions of 1999 Constitution. 1999 it's not 2024, which means that law has been there before 2024. So if a judgment relied on that constitutional provision, so why are you saying it doesn't apply to Rivers State? doesn't apply to River State local government chairman. Yeah, it's just for those people. I think something is definitely wrong with some of us. Maybe because of sheer selfish interest, ignorance, or wickedness, or they just don't want to do the right thing because of what they may benefit from it. It's like, fishing in a troubled sea. You want to do advantage of a troubled situation for your own personal interest. That's what is happening. So I think that is important for us to do. And again, the judgment also upheld the tenure elongation, of democratically elected public officers. And here there's, the argument has been that the River State House of Reps has no right to extend the tenure. But you can see from the judgment
that they actually had the right to
yes, they had. In fact, I was startled when I was reading that judgment this morning, preparing to my coming here today. I was startled that, look, that kind of provision is there. And I don't know whether, in River State, we don't have people who are, all those people, they don't know the laws of the land. We have the Attorney General of the River State. Is he saying that is not aware of that constitutional provision? Or are they just simply blindfolded by, sheer political rascality?
Is that a case of executive interference in the job of the legislature, the House of Assembly, as it were? Because you recall that a law was already passed, 3 months to the expiration of the tenure of this outcome chairman. There were calls, even prior to that time. Emmy has been on my show, and we also discussed that, calls to hold elections for council chairman, to take over. However, the governor was silent on it. And then, prior to that time, the River State House of Assembly, led by Martin Samegli, made that law, local government law number 5, extending the tenure of local government. And then another argument now came up after that, and people were saying it is not applicable to the present council chairman, that is to be applied or implemented from the next election cycle. a lot of arguments. But then, what is your take?
Yeah, you see, I just said it, I just said that, look, this judgment was based on the 1999 Constitution as amended, right? And including the elongation of tenure. But you see, because of the fact that it appears in Nigeria generally, politics now revolve around individuals and not institutions. We are supposed to have institutional supremacy, working in tandem with the constitutional provisions. But here in Nigeria, you have very strong individuals. You look at the fact that part of what the governor probably decided to conduct election as when due is the fact that, he's afraid that, well, I'm not yet on ground. There is this issue of structure. So let me put my men on ground so that the local government election will be carry-go election as they used to do, So he tactfully, decided not to do the needful at the time when he was supposed to do that, constitute or give order to the state electoral body to do the needful and conduct election. So I think it's sheer selfish interest, the fact that, look, I want to be in charge. Let me do away with all the structure, regardless of the fact that, in a democratic system of government, the political sovereignty of the people must be upheld. But unfortunately in Nigeria, because of the fact that the political sovereignty of the people have been bereft of them, people no longer decide who should become their leader through free, fair, and credible election. That's why you see, our leaders manipulate the system, like the one that is done in River State. Where you manipulate, putting your men all over the 22, so that at the end of the election, you will see 23 local government area being run by 23 members loyal to the governor. And then you now see to where we are in charge. You are in charge. But that is contrary to the wishes and aspirations of the people. Democratic system requires that it is the general will of the people that should prevail, and not personal and parochial interests or will of the few elected leaders, or few leaders. So it is important for us to realize the fundamental causative factors that have also led us to where we are now, where you don't need to actually have, local government elections when they are supposed to be, and you begin to do all manner of justifications for you to do that and do that, whereas you are neglecting the constitutional provision. All of us must look back to the Constitution. All of us, everybody.
All right. Let me, very quickly, one of the concerns that some persons that were making a case for the caretaker committees, one of the concerns they raised as to why the council elections cannot hold at that time, they said that the council elections, that it was not budgeted for, it was not in Rivers State budget. Now the question will be down the line. The governor has instructed RISEC to conduct elections. RISEC has come out to say, to release dates for the election. Now, if the election, the local government election, was not covered in the budget, where is the governor getting money now? Because, another budget has not been presented to the best of my knowledge and the knowledge of Rivers people. The question is, where is the funds for the local government election given to RISEC? Where is it coming from if it is not in the budget like a lot of people posited?
Yes, to answer your question, first I will add to the list of anomalies as pointed out by Prof here. You've talked about some with regard to the question you ask. That some people are saying that this current decision or judgment of the Apex Court is not applicable to Rivers State because Rivers State has already have their already have their caretaker and all that. I remember in this country that we used to have what they call Electoral Act 2010. There came Electoral Act 2022, right? By 2022, we have some people in government house already. We have some, because this is the second term of some governors, right? Before they became governor, they were elected under the Electoral Act 2010. How is it that the Electoral Act 2022 then became applicable to their own election? How? So if we look that it's not applicable to Rivers State, how? A law is as good as it's made. That is the positive school of law. If you don't like the law, what you do, you amend the law. But as long as you are within the territory of that law, you must submit to the rule of that law. The judgment covers Rivers State. It covers Rivers State. Another abnormality is that the State High Court has quashed the tenure elongation. Therefore, these people cannot parade themselves as chairman again, because a State High Court has nullified that law that empowers a tenure elongation. The question is, between the State High Court and the Apex Court, which is the Supreme Court, which one is higher in terms of hierarchy? So if you believe that the decision of a State High Court should be so powerful, then what about the judgment of Supreme Court? So which one do we respect more? You see, all of these things are shredded in political shenanigans. That would drive me to your question you ask. You said no money for election, but suddenly, after you've appointed your illegal structure to usurp the powers of the third tier of government, money then came. So where is the money coming from? Who budgeted for? Okay, have we seen any supplementary budget with regard to elections? SG election in Rivers State? The answer is no. So that is why I say Rivers State is currently run on illegality upon illegality equals to illegality. Right. So until we change these things and submit to the law, everything we are doing is just camouflage, which will not lead us to any substantive development, but will leave us in more crisis and crisis.
All right. Thank you so much, Emifea, for coming on Open Conversation. It's always a pleasure having you. Thank you for making our time. And thank you so much, Associate Professor Emmanuel Warner, for coming. It's always a pleasure having you on Open Conversation.
Thank you very much.
And this is where we wrap it up on this episode of Open Conversation.